Before I will start, I would like to greet first our professor a Merry Christmas and advance Happy New Year. Let me start by answering the definition of easement. Easement is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner, or for the benefits of a community or one or more persons to whom the encumbered estate does not belong, by virtue of which the owner is obliged to abstain from doing or to permit a certain thing to be done on his estate in pursuant to Articles 613 and 614. In other words, an easement is a real right constituted on another's property, which must be corporeal and immovable, and the owner of such will be abstained from doing or allowing another person to do something on his property for another thing or person's benefit. The following are the requisites for the easement. 1. The property is surrounded by estates of others and there is no adequate outlet to a public highway. Number 2. It must be established at the point least prejudicial to the servient estate, and insofar as consistent with this rule, where the distance from the dominant estate to a public highway may be the shortest. Number 3. There must be payment of the proper indemnity. And number 4, the isolation should not be due to the proprietor's own acts. The definition of servitude is it is a right of some benefit or beneficial use out of, in, or over the land of another. Or in other words, it is the registered right of a person over the immovable property of another. However, it allows the holder of the servitude to do something with the other person's property, which may infringe upon the rights of the owner of that property. An example is the right of way to travel over a section of the other person's property in order to reach your own property. The following are the distinction between easement and servitude. When we say easement, it is an English law term. When we say servitude, it is used in civil law countries. An easement or easement, it pertains to real. And when we say servitude, it is real or personal property. It pertains to the right enjoyed as to easement and burden imposed upon another as to servitude. The following are the characteristics of an easement. 1. A right limited by the needs of the dominant owner or estate without possession. 2. Inseparable from the estate to which it is attached. It is or it cannot be alienated independently of the estate. In the case of Solid Manila Corporation versus Biohong Trading Corporation, the Supreme Court held that an alley which was created as a right-of-way was included in the sale of a parcel of land on which the alley was created. The Supreme Court explained that it is true that the sale did include the alley. On this score, the court rejects the SMC's contention that the deed of sale excluded it, because as a mere right of way it cannot be separated from the tenement and maintain an independent existence. Okay, so let's move on with number 3. It cannot consist in the doing of an act unless the act is accessory in relation to a real easement. Number 4. Easement involves two neighboring estates, the dominant estate to which the right belongs and the servient estates upon which an obligation rests. Number 5. A limitation on the servient owner's rights of ownership. Number 6. Indivisible. So here it is not affected by the division of the estates between two or more persons. Number 7, it is enjoyed over another immovable, never on one's own property. And 8, a real right but will affect third persons only when registered. The following are the kinds of easements. Easements are classified as follows. 1. As to the recipient of the benefit, it is either real or personal. Number 2. As to its source, it is either legal or voluntary. In case of legal easements, it is either public legal easement or private legal easement. As to its exercise, it is either continuous or discontinuous, apparent or non-apparent, and positive or negative. Real easement or servitude, it is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner. Personal easement or servitude, the easement is in favor of a community or of one or more persons to whom the encumbered estate does not belong. Example, easement of right of way for passage of livestock. The distinction between real or personal easement. In real easement, it is the easement that is in favor of another immovable, while personal easement, it is the easement that is in favor of a community or of one or more persons to whom the encumbered estate does not belong. Example, the easement of right of way for passage of livestock. Another distinction is that in real easement, it requires two distinct immovable belonging to different owners to which it relates, while in personal servitude, the person whose in favor the easement is constituted need not to be the owner of any estate and does not require a dominant estate, because the person in whose favor the easement is constituted need not to be the proper property owner. The following are the sources of the following are the legal source or the following are the sources of easement. Number 1, legal easement and voluntary easement. Under legal easement and voluntary easement, it is said to be legal when those created by law for public use or private interest, and it is said to be voluntary easement when it is constituted by will or agreement of the parties or by testator. Next is that another sources of easement is continuous and discontinuous easement. Continuous easement, their use may or may not be incessant without the intervention of any act of man. Example, easement of drainage. And when we say discontinuous, this easement is used at intervals and depend upon the acts of man. Example, easement of right of way. Next sources is the apparent and non-apparent. When we say apparent, made known and continually kept in view by external signs that reveal the use and enjoyment of the same. And non-apparent, they show no external indication of their existence. They show no external indication of their existence. Another sources is positive and negative easement. Positive, when it imposes upon the owner of the servient estate the obligation of allowing something to be done or doing it himself. And negative, when it prohibits the owner of the servient estate from doing something which he could lawfully do if the easement did not exist. The following are the modes of acquiring easement. Number 1, by title. Number 2, by prescription of 10 years. Number 3, by deed of recognition. Number 4, by final judgment. And number 5, by apparent sign established by the owner of the two adjoining estates. When we say acquisition by title, in acquisition by title, the law refers to the juridical act which gives birth to the servitude, such as the law, donations, contracts, and wills. Hence, the act may either be inter vivos or mortis causa, may be onerous or gratuitous. All kinds of easements may be acquired by title. When we say acquisition by prescription, in this case, continuous and apparent easements may be acquired by virtue of prescription, or it means that an easement must be both continuous and apparent for it to be acquired by virtue of prescription. Next is the rights and obligations of owners of the dominant and servient estates. As to the general rights, these are the following. Number one, make on the servient estate all works necessary for the use and preservation of the servitude. The right to ask for Number two, the right to ask for mandatory injunction to prevent the impairment of his right. Number three, the right to renounce the easement if he desires to be exempt from contributing necessary expenses. Number four, the right to exercise all rights necessary for the use of the easement. Let's now move to the obligations of the dominant owner. As to his obligation, these are the following. 1. The dominant owner cannot exercise the easement in any other manner than that previously established in pursuant to Article 626. The dominant owner, number 2, cannot alter the easement or render it more burdensome in pursuant to Article 627. And number 3, the dominant owner shall notify the servient owner of works necessary for the use and preservation of the servitude in pursuant to Article 627, paragraph 2. Number 4. The dominant owner must choose the most convenient time and manner of making the necessary works as to cause the least inconvenience to the servient owner. Number 5. The dominant owner, if there are several dominant estates, he must contribute to the necessary expenses in proportion to the benefits derived from the work. And number 6, the dominant owner may make at his own expense on the servient estate any works necessary for the use of servitude, provided it will not alter or make it more burdensome. As to the rights of the servient owner, these are the following rights of the servient owner. The servient owner retain the ownership of the proportion of the estate on which easement is imposed. Number 2, the servient owner make use of the easement unless there is an agreement to the contrary. And number 3, the servient owner may change the place or manner of the use of the easement, provided it be equally convenient. The obligations of the servient's owner. The following are the obligation of the servient owner. The servient owner cannot impair the use of the easement except when the easement has become very inconvenient to the said servient owner, and if it prevents him from making any important works, repairs, or improvements thereon. Number 2. Servient owner must contribute to the necessary expenses in case he uses the easement, unless otherwise agreed upon, pursuant to Article 628, paragraph 2 of the New Civil Code. Next issue is the modes of extinguishing easement. The following are the modes of extinguishing easement. Number 1, by merger on the same person of the ownership of the dominant and servient estates. Number 2, by non-user for 10 years. So by merger, and then next is by non-user for 10 years. And then with respect to discontinuous easements, this period shall be computed from the day on which they cease to be used, and with respect to continuous easements from the day on which an act contrary to the same took place. Number 3, when either or both of the estates fall into such condition that the easement cannot be used, but it shall revive if the subsequent condition of the estates or either of them should again permit its use, unless when the use becomes possible, sufficient time for prescription has elapsed, in accordance with the provisions of the preceding number. Number 4, by the expiration of the term or the fulfillment of the condition, if the easement is temporary or conditional. Number 5, by the renunciation of the owner of the dominant estate. And number 6, by the redemption agreed upon between the owners of the dominant and servient estates. In addition to the foregoing cases, Rabuya adds the following: 1. Annulment or rescission of title constituting the easement. Number 2, termination of the right of the grantor. Number 3, abandonment of the servient estates. And number 4, eminent domain. The following are the definition of terms. We have merger. Merger, if there is merger when the ownership of the dominant and servient estates fall to one person. As previously discussed, maintaining an easement in this situation would create an absurd situation where the person would impose a servitude upon himself. There can be no merger if the easement was established for the benefit of a community, since there is no dominant and servient estates to begin with. For a real or praedial easement to be extinguished by way of merger, the merger must involve full ownership of both the dominant and servient estates. Ownership over the full extent of the servient estates is not necessary, but only the part where the servitude is established, or the part for the benefit of which the servitude was established. Next term to be defined is the non-user. Non-user as a mode of extinguishment of easement presupposes that the easement was used but later abandoned. For easement to be extinguished under this code, it is necessary that the non-user must have lasted for a period of 10 years. The commutation of the 10-year period of extinctive prescription shall depend on whether the easement is continuous or discontinuous, as follows. Number 1. If the easement is discontinuous, the 10-year period is computed from the day on which the easement was not used. Since the use of the easement depends upon the acts of man, if no such act has been executed for a period of 10 years, the easement is extinguished. Number 2. If the easement is continuous, in which case the use of the easement does not depend upon the acts of man. The 10-year period is counted from the day on which an act contrary to the easement took place. For example, if the owner of the lower estate constructed a series of dikes to prevent the flow of excess waters coming from the higher estates, the legal easement of drainage is extinguished 10 years after the construction of the dikes. Non-user, if the dominant estate is under a state of co-ownership, the use of the easement by any of the co-owners will prevent the running of the 10-year period of extinctive prescription by non-user. Next term to be defined is impossibility of use. If there are circumstances which rendered impossible the use of the easement, the same is merely suspended until subsequent condition shall again permit the use of the easement. In the following situations, however, the easement is not merely suspended but extinguished. 1. If the circumstances which cause the impossibility of use shall be irreparable, in which case the easement is absolutely extinguished. Number 2. If the circumstances which cause the impossibility of use are reparable, the easement is likewise extinguished if the period of extinctive prescription by non-user has already lapsed. In the latter case, the circumstance which renders the use of the easement impossible must not be in the nature of a fortuitous event. Otherwise, the easement may not be extinguished by non-user, in which case the easement is merely suspended. According to Senator Tolentino, the non-user must be due to voluntary abstention by the dominant owner, and not to fortuitous event, because the basis of this cause of extinguishment is presumptive renunciation. Renunciation, it is, or the renunciation of the easement by the owner of the dominant estates must be specific, clear, and express. A tacit renunciation will not be sufficient. Next word to be defined is redemption. The redemption being referred to in the law on is the release of the servient estates from the servitude upon agreement of the owners of both estates, and upon payment by the owner of the servient estates of the corresponding consideration to the owner of the dominant estate. The following are the different legal easements: public legal easement and private legal easement. We have also the following: easement relating to waters, easement of right-of-way, easement of party wall, easement of light and view, easement of drainage of buildings, easement of distances, easement of nuisance, easement of lateral and subjacent support. Next issue is compulsory easement of right-of-way. Easement of right-of-way is the right granted to a person or class of persons to pass over the land of another by using a particular pathway therein, to reach the former's estates which have no adequate outlet to a public highway, subject however to payment of indemnity to the owner of the land burdened by the right. An easement an An easement of right of way may only be acquired by virtue of a title, either voluntarily or compulsory. A voluntary easement of right of way is constituted by covenant and does not therefore require that the dominant estates be isolated and without an adequate outlet to a public highway. The consequence is that the dominant estates cannot demand a right of way if there are other more adequate and convenient outlets to a public highway. If an estate, however, is so isolated and without an adequate outlet to a public highway, the grant of easement of right of way is compulsory and hence legally demandable, subject to indemnity and the concurrence of other conditions set forth by law. The indemnity and conditions refer to the payment of the damage caused by the encumbrance and the condition that the right of way shall be established at the point least prejudicial to the servient estate, and insofar as consistent with the previous rule, where the distance from the dominant estate to a public highway may be the shortest. In one case, the Supreme Court held that a compulsory easement of right-of-way cannot be obtained without the presence of four requisites. 1. That the dominant estate is surrounded by other immovable and has no adequate outlet to a public highway. 2. After payment of proper indemnity. 3. That the isolation was not due to acts of the proprietor of the dominant estate. And number 4. That the right of way claimed is at the point least prejudicial to the servient estate, and insofar as consistent with this rule, where the distance from the dominant estate to a public highway may be the shortest. Next issue is the easement of party wall. It is a right granted against a wall erected on the line between the adjoining properties between the adjoining properties belong to different persons for the use of both estates governed by 1. The Civil Code, 2. The local ordinances and customs, and 3. The rules on co-ownership. The law presumes the existence of an easement of party wall in the following cases. 1. In dividing walls of adjoining buildings up to the point of common elevation. 2. In dividing walls of gardens or yards situated in cities, towns, or rural communities. And 3. In fences, walls, and live hedges dividing rural lands. This presumption will not, however, apply if there is title to the contrary, if there is an exterior sign to the contrary, and if there is proof to the contrary. It is understood, however, that there exists an exterior sign contrary to the easement of party wall in the following instances. 1. Whenever in the dividing wall of building there is a window or opening. 2. Whenever the dividing wall is on one side straight and plumb on all its pavement, and on the other it has similar conditions on the upper part, but the lower part is slants or projects outward. Number 3. Whenever the entire wall is built within the boundaries of one of the estates. Number 4. Whenever the dividing wall bears the burden of the binding beams, floors, and roof frame of one of the buildings, but not those of the others. Number 5. Whenever the dividing wall between courtyards, gardens, and tenements is constructed in such a way that the coping sheds the water upon only one of the estates. Number 6. Whenever the dividing wall being built of masonry has stepping stones, which at certain intervals project from the surface on one side only, but not on the other. 7. Whenever lands enclosed by fences or live hedges adjoin others which are not enclosed. In all the foregoing cases, the ownership of the walls, fences, or hedges shall be deemed to belong exclusively to the owner of the property or tenement, which has in its favor the presumption based on any one of these signs. With respect to ditches or drains open between two estates, there is also a presumption that they are common to both estates unless there is a sign or title to the contrary. There is a sign contrary to the part ownership whenever the dirt removed to open the ditch or to clean it is only on one side thereof, in which case the ownership of the ditch shall belong exclusively to the owner of the land having this exterior sign in its favor. Rights and obligations of each co-owner of party wall. Right to use. Every part owner of a party wall of a party wall may use it in proportion to the right he may have in the co-ownership, even without the consent of the other owners, so long as he does not interfere with the common and respective uses by the other co-owners. Right to increase heights of party wall. Every part owner of a party has the right to increase the height of the party wall, subject to the following conditions. 1. The same shall be done at his expense. 2. He shall pay for any damage which may be caused by his work, even though such damage may be temporary. And number 3. If the party wall cannot bear the increased height, the owner deciding to raise it shall be obliged to reconstruct it at his own expense. And if for this purpose it be necessary to make it thicker, he shall give the space required from his own land. Number 4. Any increase shall belong to the one who raised the wall. The expenses in maintaining the added height and the wall itself due to the added height shall be borne by the one who increased the wall's height. If the co-owners of the wall contribute to the expenses of raising the height, they shall also share in the increased height and its expenses in proportion to their contribution. Next is the repairs and maintenance of party wall. The cost of repairs and construction of party walls and the maintenance of fences, live, hedges, ditches, and drains owned in common shall be borne by all the owners of the lands or tenements having the party wall in their favor, in proportion to the right of each. Nevertheless, any owner may exempt himself from contributing to this charge by renouncing his part ownership, except when the party wall supports a building belonging to him. In case where the party wall supports a building, the owner of such building may renounce his part ownership of the party wall if he will demolish the building. But the cost of all repairs and work necessary to prevent any damage which the demolition may cause to the party wall on this occasion shall be borne by him. Easement of light and view. A building may receive light in various manners in the enjoyment of an easement of light, because the openings through which the light penetrates may be made on one's own wall, in the wall of one's neighbor, or in a party wall. No part owner may, without the consent of the others, open through the party wall any window or aperture of any kind. It is necessary to obtain the consent of the other co-owners when the opening is to be made in a party wall. If the same is done without the consent of the other co-owners, the latter may demand that what has been done be undone at the expense of the one who made such opening. But if the same is done with the consent of the other co-owners, the 10-year period of prescription for the acquisition of an easement of light and view shall commence to run from the time of the making of such opening. The easements of light and view go together because an easement of light and view requires that the owner of the servient estate shall not build to a height that will obstruct the window. They are two sides of the same coin. So while an easement of light and view is positive, that of altus non tolendi is negative. The easement of lights in the case of windows opened in one's own wall is of a negative character, and as such cannot be acquired by prescription under Article 61 of the new Civil Code, except by counting the time of possession from the date on which the owner of the dominant estates may, by an instrument acknowledged before a notary public, may have prohibited the owner of the servient estate from doing something which it would be lawful for him to do were it not for the easement. The law prohibits the making of projections which afford a direct view upon or towards an adjoining land or tenement without leaving a distance of 2 meters from the outer line of the wall to the contiguous property, when the opening do not project from the outer line of the latter when they do. With respect to the side or oblique views upon or towards such coterminous property, the law requires that the distance be 60 centimeters from the dividing line between the properties. The foregoing requirements does not apply, however, to buildings separated by a public way or alley, which is not less than 3 meters wide, unless there is a special regulation in local ordinances which provides to the contrary. The distance requirement need not be followed if 1. The opening must not be more than 30 centimeters square and made at the height of the ceiling joist or immediately under the ceiling, and with an iron grating embedded in the wall and with a wire screen. And number 2, it must be for the purpose of admitting light only and not for the purpose of view. If the distance requirement is violated and the violation is not exempt, the remedy is to have the openings ordered closed because they constitute unlawful openings. In the alternative, the owner of the property adjoining the wall may compel that the opening comply with the exception requirements. Since the easement is -1, the 10-year period begins to run only from the time of the formal prohibition made by the owner of the dominant estate in a notarized document. Next issue is the easement of drainage of buildings. The owner of a building shall be obliged to construct its roof or covering in such manner that the rain water shall fall on his own land, or on a street or public place, and not on the land of his neighbor, even though the adjacent land may belong to 2 or more persons, one of whom is the owner of the roof. Even if it should fall on his own land, the owner shall be obliged to collect the water in such a way as not to cause damage to the adjacent land or easement. An easement of drainage may be demanded subject to compliance with the following requisites. 1. The yard or court of a house must be surrounded by other houses, the dominant estate, and it is not possible to give an outlet through the house itself to the rain collected therefrom. Number 2. The outlet to the water must be at the point of the contiguous lands or tenements, or the servient estates where its egress may be easiest. Number 3. The conduit for the drainage must be established in such manner as to cause the least damage to the servient estate. And number 4. Proper indemnity must be paid to the owner of the servient estate. Intermediate distance for learning. No constructions can be built or plantings made near fortified places or fortresses without compliance with the conditions required in special laws, ordinances, and regulations relating thereto. Planting of trees. Article 679 establishes a negative easement. It provides the minimum distances of trees and shrubs from the boundary line. They shall be regulated by the local ordinances, and in the absence thereof, by the customs of the place, and in default thereof. Distance in planting of trees under Article 679 of the new Civil Code. 1. The distance authorized by local ordinances or customs of the place, if any. Or 2. If there are no ordinance or custom, at least 2 meters from the dividing line of the estates in case of tall trees, and at least a distance of at least 50 centimeters in case of shrubs or small trees. Violations will grant the owner of the adjacent land the right to demand for the uprooting of the trees which were planted in violation of the rule. These remedies also available to the owner of the adjacent land, even with respect to trees which have grown spontaneously at distances shorter than that required. An owner may cut off roots, which enter his or her property but not the branches. He or she must demand that the owner of the tree cut the branch, and if the owner refuses, go to court and demand that the branches be cut. Next issue is the lateral and subjacent support. When we say lateral support, this is the support on the vertical side of a land, the removal of which may cause the land to crumble or slide. Support is lateral when the supported and the supporting lands are divided by vertical plane. Subjacent support. This is the horizontal support underneath a land or building, the removal of which may cause the sinking or crumbling of the land or building. Support is adjacent when the supported land is above and the supporting land is beneath it. The law prohibits any excavation upon one's land if the same will deprive any adjacent land or building of sufficient lateral or subjacent support. In addition, the law prohibits any stipulation or testamentary provision allowing such kind of excavation. Any such stipulation or testamentary provision is expressly declared to be void. If the right of lateral and subjacent support is violated, the adjoining landowner is entitled to seek injunctive relief in addition to the right to recover damages. In other words, no proprietor shall make such excavations upon his land as to deprive any adjacent land or building of sufficient lateral or subjacent support. Remedies for violation of Article 684. Claim for damages for injury sustained or injunction. And nuisance. So next issue is nuisance. A nuisance is any act, omission, establishment, business, condition of property, or anything else which 1. Injures or endangers the health or safety of others. 2. Annoys or offends the senses. 3. Shocks, defies, or disregards decency or morality. 4. Obstructs or interferes with the free passage of any public highway or street or any body of water. Or number 5. Hinders or impairs the use of property. The law on nuisance is related to Article 431 of the new Civil Code. It specifically mandates that the owner of a thing cannot make use thereof in such a manner as to injure the rights of a third person, because it is a restriction or limitation upon ownership and a manifestation of the principle that every person should so use his property as not to cause damage or injury to others. If nuisance will result in injury to another person, the law allows recovery of damages. Rabuya quotes Judge Sanko as saying, "A nuisance is a tort governed by the rules on tort generally, so that as in the case of other torts, legal liability for a nuisance is predicated on an invasion of the plaintiff's legal rights by an act not warranted by law or from a neglect of duty imposed by law that results in damage to another." While nuisance is a tort, it differs, however, from negligence. Liability for negligence is based on want of a proper care, while ordinarily a person who creates or maintains a nuisance is liable for the resulting injury to others, regardless of the degree of care or skill exercised to avoid such injury. However, a nuisance may be and frequently is the consequence of negligence, or the same acts or omissions which constitutes negligence may be give rise to a nuisance. The following are the kinds of nuisance. As to the number of persons affected: 1. Public. 2. Private. Other classifications: we have 1. Nuisance per se, nuisance per accidents, temporary, permanent, continuing, intermittent, attractive nuisance. A public nuisance affects a community or neighborhood or any considerable number of persons, although the extent of the annoyance, danger, or damage upon individuals may be unequal. Private nuisance, on the other hand, affects only an individual or a limited number of individuals. In order for a private nuisance suit to prosper, the plaintiff must be able to prove two things: that were that there was damage to the property, and the interference is either 1. Intentional and unreasonable, or unintentional and otherwise negligent or reckless conduct, or 3. Resulting in abnormally dangerous activities in an appropriate place. Next issue is the remedies against nuisance. Remedies against public nuisance: 1. Prosecution under the revised penal code or any local ordinance. 2. Civil action. 3. Abatement without judicial proceeding. Remedies against private nuisance: 1. Civil action. 2. Abatement without judicial proceedings. Next issue is abatement. Abatement may either be without the necessity of judicial proceedings or only upon due hearing thereon. In a number of cases, the Supreme Court clarified, however, that the abatement of a nuisance without judicial proceedings is possible only if it is nuisance per se. In Salau versus Santos, the court explained, nuisances are of two kinds: nuisance per se and nuisance per accidents. The first is recognized as a nuisance under any and all circumstances, because it constitutes a direct menace to public health or safety, and for that reason may be abated summarily under the undefined law of necessity. The second is that which depends upon certain conditions and circumstances, and its existence being a question of fact, it cannot be abated without due hearing thereon in a tribunal authorized to decide whether such a thing does in law constitute a nuisance. Under the law, it is the city and or the municipal health officer, or in cases of illegal construction, the city and or municipal engineer, who is charged with the responsibility of abating public nuisances. A private person may likewise abate a public nuisance which is especially injurious to him, by removing, or if necessary, by destroying the thing which constitute the same, without committing a breach of the peace, or doing unnecessary injury. Prior to the abatement, it is necessary: 1. That demand be first made upon the owner or possessor of the property to abate the nuisance. 2. That such demand has been rejected. 3. That the abatement be approved by the district health officer and executed with the assistance of the local police. And number 4, that the value of the destruction does not exceed 3,000 pesos. The same procedure shall be applied in case of extrajudicial abatement of a private nuisance by any person injured by the same. A private person or a public official who extrajudicially abates a nuisance shall be liable for damages in the following situations: 1. If he causes unnecessary injury, or 2. If an alleged nuisance is later declared by the courts to be not a real nuisance. Next is prescription. Prescription means of acquiring. It is the means of acquiring. Prescription is the means of acquiring ownership and other real rights or losing rights or action to enforce such rights through lapse of time, in the manner and under the condition laid down by law. In the case of Kaliktan versus Sedania, GR number 155080, 2004, the Supreme Court held that prescription is another mode of acquiring ownership and other real rights over immovable property. It is concerned with lapse of time in the manner and under conditions laid down by law, namely that the possession should be in the concept of 1. An owner, b. Public, c. Peaceful, d. Uninterrupted, and e. Adverse. The following are the requisites of prescription. 1. Capacity to acquire by prescription. 2. A thing capable of acquisition by prescription. 3. Possession of the thing under certain conditions. And 4. Lapse of time provided by law. The following are the different kinds of acquisitive prescription. But what is the concept of acquisitive prescription? Acquisitive prescription is a mode of acquiring ownership by a possessor through the requisite lapse of time. In order to ripen into ownership, possession must be in the concept of an owner, peaceful, public, and uninterrupted. Thus, the following are the kinds of acquisitive prescription. 1. Ordinary acquisitive prescription, and 2. Extraordinary acquisitive prescription. Under ordinary acquisitive prescription, it requires possession of things in good faith and with just title for the time fixed by law. Under the law, possession has to be in the concept of an owner, public, peaceful, and uninterrupted. Next kinds is the extraordinary acquisitive prescription. When we say with extraordinary acquisitive prescription, this involves without good faith and just title. Acquisitive prescription can only be extraordinary in character. Period of prescription. As in real property, 10 years if possession of things in good faith and with just title, and prescribed in 30 years if the acquisition of ownership and other real rights without the need of title or of good faith or in any other condition. As to personal property, 4 years if ownership of movables is uninterrupted, and it is 8 years if uninterrupted without need of any other condition. Let's move on with laches. Laches is the failure or neglect to assert a right within a reasonable time or in relation to property. It involves loss of property rights or actions through the possession by another of a thing for the period provided by law, or failure to bring the necessary action to enforce one's rights within the period fixed by law. Rights and actions are lost by the lapse of time. In the case of Tiham et al. Versus Sibong Hanoy, in 1963, the Supreme Court defined estoppel by laches as failure or neglect for an unreasonable and unexplained length of time to do that which, by exercising due diligence, could or should have been done earlier. In another case, Miguel versus Catalino, 1968 case, the Supreme Court enumerated the following elements of laches, namely: 1. Conduct on the part of the defendant or of one another whom he claims, giving rise to the situation of which complaint is made and for which the complaint seeks a remedy. 2. Delay in asserting the complainant's rights, the complainant having had knowledge or notice of the defendant's conduct and having been afforded an opportunity to institute a suit. 3. Lack of knowledge or notice on the part of the defendant that the complainant would assert the rights on which he bases his suit. And 4. Injury or prejudice to the defendant in the event relief is accorded to the complaint or the suit is not held to be barred. In the case of Buenaventura versus Court of Appeals, 1992 case, the Supreme Court provides the distinction of laches versus prescription in the following. Prescription is concerned with the fact of delay, whereas laches is concerned with the effect of delay. Number 2. Prescription is a matter of time. Laches is principally a question of inequity of permitting a claim to be enforced. This inequity being founded on the same change in the condition of the property or the relation of the parties. Number 3. Prescription is statutory. Laches is not. Number 4. Laches applies in equity, whereas prescription applies at law. Thank you.